Elder abuse. Specialized California legal protections for senior citizens. This presentation is not intended as legal advice nor to establish an attorney-client relationship. Rather, it is merely a broad overview of the subject matter intended solely for educational purposes. If you believe you may have a claim, you should promptly consult an experienced attorney. Note that delay may result in an inadvertent waiver of valuable legal rights and remedies. The Elder Abuse and Dependent Adult Civil Protection Act. These laws are designed to specifically protect California senior citizens from various forms of abuse, including by family, caretakers, and third parties. This presentation specifically focuses on financial elder abuse. Protected parties under these statutes are defined as individual California residents aged 65 or older at the time of the wrongful conduct. The Act is not designed to protect harmed entities that are owned by senior citizens. It only protects the individuals themselves. Civil financial elder abuse occurs when any of the following is committed by a person or an entity: the taking or secreting of real or personal property of an elder for a wrongful use, or with intent to defraud, or both, or assisting in the taking or secreting of the real or personal property of an elder for wrongful use, or with intent to defraud, or both, or taking, secreting, or assisting in the taking or secreting of the real or personal property of an elder by means of undue influence, which is a term of art that is legally defined. Now, for purposes of that definition, the term wrongful use means that the person knew or should have known that his or her conduct was likely to be harmful to the elder. And the term undue influence is defined as excessive persuasion causing another person to act or refrain from acting by overcoming that person's free will and then resulting in inequity or unfairness to that person. The following are several examples of prohibited financially abusive conduct. This is a non-exclusive list. 1. Misuse of a power of attorney, including using a senior citizen's money for the personal benefit of the person holding the power of attorney versus for the benefit of the elder. 2. Misuse of promissory notes, real property deeds, or deeds of trust, including by means of forgery. 3. Taking the money, personal, or real property of a senior, including borrowing without repayment. 4. Forcing or tricking the senior into giving away or transferring title to property. 5. Use of fraud, coercion, or undue influence to wrongfully obtain property from an elder. 6. Churning. Churning is where a financial advisor, insurance broker, or similar person causes a senior to make investments or changes to insurance coverage that are likely to result in losses to the senior, just so that the advisor or broker can make a commission on each of those transactions. Please click the thumbs up button and the bell icon for this video. This helps the YouTube algorithm provide wider distribution for this video to other users. Now, under the Act, either a competent senior or his or her representative can cause a lawsuit to be filed against an alleged wrongdoer, which would be either a person or an entity accused of financial abuse. The term representative includes a conservator, a trustee, an attorney in fact, or a person who acts within the authority of a power of attorney. Unlike the senior plaintiff, who may only sue if he or she is an individual, the defendant may be either a person or an entity. Claims under the Act may be brought, for example, against lenders, brokers, brokerages, employers, agents, fiduciaries, caretakers, family members, etc. A lawsuit may be filed by or on behalf of the senior victim against the wrongdoer within 4 calendar years from the date of the wrongful conduct having occurred. Note, however, that in some instances, if the plaintiff can prove that the wrongful conduct could not have been discovered earlier, during that 4-year period referenced above, for example, where it was intentionally hidden by the wrongdoer, the statute of limitations may be told or extended beyond that 4-year limitations period. Where a lawsuit is filed on behalf of a senior plaintiff, the senior will have the burden of proof to show that he or she was damaged by financially abusive conduct by the defendant. The senior must meet that burden by a more likely than not or a preponderance of the evidence standard, which is 50.1% or greater likelihood as to each and every one of the legal elements of financial elder abuse. Now, under the Act, the primary remedy available to the prevailing senior plaintiff will be compensatory damages, also known as a money judgment award in an amount sufficient to compensate the senior for financial losses he or she can prove he or she actually suffered. Now, alternatively, the court may order the return of the underlying property itself that had been taken improperly. In addition, in certain egregious cases, the plaintiff may also seek and obtain an award of punitive damages, which is an additional monetary award over and above the compensatory damages we just discussed, that is sufficient to punish the wrongdoer for morally reprehensible extreme conduct. In order to earn a punitive damages award, however, the elder must establish that the defendant committed the abuse with recklessness, oppression, fraud, or malice, and then must do so by a higher, more challenging standard of proof known as the clear and convincing standard. The Act also provides that a successful senior plaintiff shall also be awarded an additional sum equal to his or her incurred attorney's fees and costs in litigating the claim. If you're getting value out of the video and have not already clicked the like and subscribe buttons, please consider doing it now. We greatly value and appreciate your support, and thank you in advance. Under the Act, in addition to the foregoing, early in the lawsuit process, a plaintiff may elect to apply for what's called a prejudgment writ of attachment against the defendant. This may be granted where plaintiff can demonstrate the probable validity of the financial abuse claim. When granted, this provisional remedy freezes the assets of the alleged wrongdoer, so those assets will be available if and when plaintiff wins the case. It grants the plaintiff a lien and prevents the defendant from squandering those assets during litigation. When granted, particularly when granted early in the case, this remedy often coerces the defendant into settling the action, thereby sparing plaintiff from expending valuable time and resources in protracted litigation. And then there's the elder or dependent adult protective order, separate from the main lawsuit, in a separate mini action. A protective order, sometimes referred to as a restraining order, may also be obtained by or on behalf of the senior plaintiff against the alleged abuser. So the main actions for money damages and this little mini action for protective order is primarily for purposes of obtaining a restraining order. You don't have to do both, but you can. A protective order may be petitioned for by a conservator, a trustee, an attorney in fact who acts within the authority of the power of attorney, or any other authorized person acting on behalf of the elder. The good news is there's no filing fee required for the protective order action, which is known as a petition, nor can the petitioner, who is the plaintiff, be required to pay a fee for law enforcement to serve the order. The prevailing party may be awarded court costs and attorney's fees in connection with issuance of the protective order or denial of that petition. An elder abuse protective order may prohibit and restrain the defendant from contacting, abusing, approaching, or coming within a specified distance of and or harassing the senior citizen. Violations of an entered and properly served protective order may result in the immediate arrest and subsequent criminal prosecution of the offending restrained person, who in this context of a petition is known as the respondent. In order to prevail at with a protective order, the elder petitioner must demonstrate in a mini trial sort of hearing that often occurs within 30 days after filing of the paperwork with the court that financial abuse was committed against the senior by the respondent. The standard of proof is the more likely than not preponderance of the evidence standard, which is exactly the same standard that applies to the main money damages lawsuit that we talked about earlier. In these protective order actions, witnesses and documentary evidence may be presented at that mini trial hearing. The hearing is often more informal than a traditional trial, and it features relaxed evidentiary standards. This makes it more speedy and more efficient to rule on these petitions. The process is often substantially expedited when compared to a regular civil lawsuit, such as a lawsuit for financial elder abuse for money damages. Call Benjy Law Corporation for a free consultation. We offer a free 1-hour legal consultation with an experienced financial elder abuse attorney. This can be done either in person at our office in Beverly Hills, remotely via Zoom or FaceTime, or telephonically. The good news is the consultation is free of any obligation and completely confidential and protected from disclosure to third parties by the attorney-client privilege, even if we're not ultimately retained as your legal counsel. To make an appointment, please call us at 310 area code 203-2650. That's 310-203-2650. Or email us at info@benjylaw.com. That's info at benjy like yellow law.com. This concludes this video. We hope you found it informative and useful.